South Africa commemorates Human Rights Day. We remember the 69 people killed in the Sharpeville massacre on the 21st of March in 1960 by apartheid-era police. They are protesting against the inhumane past laws, but despite the United Nations declaring apartheid a crime against humanity in 1973, not a single politician or security police has been indicted. Joining me now to talk about this is human rights lawyer Yasmin Sooka. Yasmin, good evening and thank you for your time tonight. Is the NPA unwilling or incapable to prosecute apartheid-era crimes?
I guess that's the question. Good evening to you and your listeners. But I guess that's the question that I and many victims are asking, because there are two issues. You know, when you look at the crime of apartheid and the fact that apartheid was declared a crime against humanity, it's quite shocking that despite the Constitutional Court declaring that murder, torture, persecution, forced removals and enforced disappearances constitute, practices under the crime against humanity, not a single politician was indicted. And when you look at the TRC cases, in 1998, we handed a list of 300 cases to the NPA. And in the period since then, we have only seen 2 indictments. The indictment in the case of Nokuthula Simelane, who was the subject of an enforced disappearance by a death squad, and that of Ahmed Timol after the historic inquest was opened into his death. And Judge Billy Motley recommended that, in fact, the living or the surviving perpetrator, Jean Rodrigues, be indicted. But what's even more shocking is that none of these cases have come to trial yet. And many of the victims whom we represent ask the question, is there a deliberate delay on the part of the NPA? Do they want more perpetrators to die? Because in the last 5 years, we've seen many of the key interrogators passing on. And so many families ask the question, are we ever going to see justice in our lifetimes? And so one of the questions we are asking is, in the Timor matter, when it went on appeal, there were a number of affidavits which alleged that there was political interference. One of the NPA prosecutors indicated that by 2003, they had been told that there would be no investigations in these cases. And in 2015, when Tembi Nkadimeng, the sister of Nokuthula Simelane, brought an application in the High Court to compel a decision in her sister's case, you had the then head of the NPA, Vusi Pikoli, putting an affidavit before the court saying that he had been told to lay off the TRC cases. And in fact, in the appeal court case, in the Timor matter, the court confirmed that there was political interference. And so a question that victims are asking is, the court ordered that there be an inquiry both on the side of the executive and on the side of the NPA, so that in fact we understand what are the structural impediments to dealing with these cases. Yeah. I think you would agree with me that it's a shameful thing as we commemorate 27 years of freedom that you've only had 2 indictments. What about the families?
Even those 2 indictments came about because of the families' insistence. I mean, one would ask how many investigations were actually initiated by the NPA itself.
Well, I think that's something that we've been trying to get to the bottom of, because we have, many families who are asking us to deal with these cases. And in fact, we are in correspondence with the NPA on them. And on one of them, the Craddock 4 case, for instance, last year in May, the NPA was supposed to give us a decision on an indictment, and we are sitting almost a year later with no decision. And so one of the widows, Mrs. Mboyi Mklauli, said to me, what's going on? Is there something wrong? And just remember that last year, Nyameka Ganiwe died. Yeah. So, the question we have to ask is, what is happening at the NPA?
Let's talk about that. Is it a lack of an understanding of, and I'm sure you can expand on this idea a little bit more, what transitional justice actually means when we talk about the range of processes cases that needs to follow associated with society's attempt to actually come to grips with actually what happened. And that would be a range of issues that should ensue, that would ensure accountability, justice is achieved, and reconciliation is achieved.
Yeah, you know, it's widely understood that transitional justice really is referring to what you do when you have a transition from one regime to another, and what you do with those who are responsible for what we call crimes against humanity or war crimes or genocide. Now, in the case of South Africa, you will recall that one of the compromises that was made was that there would be an individual application for amnesty, and provided you made full disclosure, you would not be prosecuted or go to prison. And this was encapsulated in the interim constitution. Now, transitional justice focuses on what we call 4 elements: the right to the truth for victims, the right to criminal justice, the right to reparations, and of course what we call the guarantee of non-recurrence. Now, in the case of South Africa, we opted almost for a 2-phase, process. On the one hand, you would have the Truth Commission, which would enforce this right to the truth. And secondly, those who did not apply for amnesty or refused amnesty, it was always understood in the law that the law would then follow its course. And that is why the TRC, at the end of its first report, handed over this list of alleged perpetrators to the NPA with a view that they should take them over, they should investigate further, and in fact, where the evidence exists, they should prosecute. Now we know from the 2 cases that came before the courts, in terms of the application to compel a decision, and then, of course, the appeal hearing in the Timor matter, we know that there was political interference, and we know that there was a decision on the part of both the executive then, the NPA, and the Hawks to suppress the prosecution of the TRC cases. And so it's not surprising that so many years down the line, we still have no movement on these cases. Now, of course, in 2019, when we had a new head of the NPA appointed, all of us were incredibly excited. And in fact, we went to have a number of meetings with the new head of the NPA. We also had a workshop with them in October 2019. And they convinced us at that workshop that they were passionately committed to taking up these cases. Well, 2021, and we've seen no action, and there's very little to show for that workshop. And so rightfully, we are saying to the executive and the NPA, we need some kind of inquiry, both into the behavior of the then executive to understand why they didn't want these cases to proceed. And in the case of the NPA, we want to know which of your officials were implicated in the suppression of the TRC cases so that we can weed them out and we can ensure that, in fact, we have a proper team to deal with these cases. We have also said to them that we think the only way these cases are going to work is if they give us a dedicated unit, which is made up of both prosecutors and investigators, and it needs to be led by a special head so that it gets the kind of attention that it needs so that we can succeed in these cases. And that's the kind of discussion that we've been having with them, and one that we intend to have with the executive as well. It's also why me and my colleagues, former TRC commissioners, we've written another letter to the president. We wrote one in 2019, which he acknowledged but didn't bother to do anything about. And so we've written to him again and we've said, set up a commission of inquiry because you are not doing anything about ensuring that these cases are going to be heard. And we need to be sure.
Not only that, Yasmin, but we also know that the Zondo Commission is also looking at a submission that argues that the NPA was captured in relation to the prosecution of the TRC cases. Do you think the Zondo Commission would have time to look at that? I mean, considering the scope of the work that they need to do.
Well, you know, Lukanya Kalata and a number of the families of victims made that submission to Judge Zondo and argued, in fact, that in fact, the NPA and the horse had been captured. And that is why we needed him to have a look at this, and that this constitutes corruption of a different kind, corruption actually of state institutions. Now, Judge Zondo has, we thought that he was going to hear this matter, but given that he only has 3 months to go, we are not sure if he's ever going to deal with this matter, and this is going to be a disaster, really, for the families of victims. And that is why we need to know that the President and the NPA are going to take this issue seriously, so that we can understand what are the blockages. I mean, the question you ask me, are they incompetent, or is it a question of will? And I think, is it a question of political will that is stopping them from dealing with these cases? I can only say that in our interchange with them, we have also come across incredibly difficult structural issues, because one of the arguments we are having with them is that they need to prosecute these crimes not as ordinary criminal matters. After all, apartheid was declared a crime against humanity, and all of these crimes should be prosecuted as such. If you look at Section 232 of the Constitution, which deals with the question of customary law in our country, and you deal with the judgment in the Basson case, then there should be no impediment to doing so. And in fact, by refusing to do so, they almost indicate that these policemen or security branch members were on a private frolic of their own. And we know that these are what we call systems or political crimes of the state, and they need to be treated as such. But this is the kind of argument you have. And I mean, we've prepared a number of legal opinions so that we can actually show them that this is the right way to go. But of course, in the absence of political will, or in the absence of competent prosecutors to deal with these cases, we are at the standstill that you see us now.
Human rights lawyer Yasmin Sooka with us tonight here on the Newsfeed Late Night. A focus tonight here on the Newsfeed Late Night, looking at the MPA and the prosecution of apartheid-era crimes, in conversation with human rights lawyer Yasmin Sooka. Now, Yasmin, before the break, we touched a little bit on the fact that you and alongside other TRC commissioners have already written to the president twice now, once again, saying you need to do something about this. Let's talk about what the impact of this is, and tell me what your view is on this thought that the impunity that exists in matters of crime today in the country actually emanates from the failure or the lack of will from the NPA to prosecute apartheid-era crimes.
I would actually argue that the impunity actually began at the time of the transition. While I accept that perhaps the amnesty was necessary for democracy to begin in our country, I believe that that compromise, where we agreed not to prosecute apartheid's criminals, may be the start of impunity in our country. Not that there was not impunity in the years of apartheid, but I think that the democratic regime almost began on the basis of an exchange of truthful full disclosure. And of course, when they failed to prosecute those who had not applied, that is when the impunity actually began. And remember that under international law, South Africa is under an obligation to deal with the crimes of the past, and in fact to investigate, and where evidence exists, to prosecute. Now, nothing like that has happened in our country. And of course, what we have said to both the government and the NPA is that when you look at other countries who have had to walk the same kind of journey that we have had, and we prepared a legal opinion which set out comparative best practices across the world in dealing with these kinds of crimes. And we showed them that in countries like Argentina, in Germany, that when you had a dedicated unit, then of course, this is when you really begin to see prosecutions. We also sent them a second legal opinion in which we set out the legal framework under South African law to establish such a unit. And in fact, we modeled it on the existing commercial crimes unit, which is seen to many people, it seems to be reasonably successful. And so we were saying to them that if you have the political will, if you really want to do the right thing by victims who actually gave up their lives for the kind of freedom we enjoy, then this is the way you can actually do it. And of course, this is where we are looking for some kind of accommodation, right, so that we can go forward.
So now, with those types of recommendations that you've made to them, what do you think then really is behind the NPA's lack of capacity to actually really carry this out? Is it a lack of funding, and therefore, I mean, I know you've also suggested that then if it is a lack of funding, they must then go look at independent funding for the NPA to guarantee its independence?
Well, I think it's not just a question of funding. I think it is a question of political will. And I think it is about doing the right thing. If we agree that this is the right way to go, and bear in mind that right now the NPA can argue that they have so many cases that they're actually overwhelmed. But then if you put, you put down the fact that we hardly see anybody indicted, even on corruption cases, except for the last stream of the VBS perpetrators last week. The reality is that perhaps you need a team that can focus solely on these cases, and that is what we are suggesting. Then, of course, in terms of funding, I am convinced that if we agree that this is the right thing to do, then together we can try and find the funds. And it may well be that we will need to look at other donor countries. We may have to find funding in the country itself. But isn't that a better prospect than stringing victims along for a period of 27 years? That is just completely unacceptable.
Now, do you think you could make a successful legal challenge of this deal that is seemingly in place with apartheid-era security policemen whose pensions are seemingly guaranteed?
Well, that's another iniquitous issue. The fact that they can take us all the way to court and their fees are paid for by the state. So someone like João Rodrigues, who's been in court on so many occasions, finally ending up in the Supreme Court of Appeals, he in fact had all of his fees paid for by the state. And our clients, in these cases, we've had to fundraise to support their costs. That is unacceptable, and it's outrageous, really. When you look at this kind of inequality, it simply creates a huge bitterness on the part of victims. And so I think that there is a case to be made for the fact that their pensions are intact. Their legal fees, sometimes we sit in court with 6 different sets of attorneys and senior counsels handling one matter simply to protect the rights of perpetrators. And on the side of the victims, we've had to fundraise privately. That is so outrageous that, our clients just don't believe that their families and loved ones died in the cause of freedom, but this is how the new democratic state has treated them.
Yeah. Now, in light of transitional justice and, of course, the conversation that essentially seems to indicate that we are getting the short end of the stick, are we being fed reconciliation without justice here, and what's the impact?
Well, reconciliation can only come with justice. You will agree. And that is that it is based on the fact that there has been truth, that there has been reparations, and in those cases where perpetrators did not, in fact, come forward, then, of course, the law should follow its course. And that can be the only sustainable basis for reconciliation. Otherwise, it's cheap and unacceptable. And this is not how reconciliation is considered, because let's be honest, on the side of the victims, has the quality of their lives changed? On the side of the perpetrators, they've gone free. And many of them, in fact, argue that we should move on. Why are we still harping on these cases? But it also raises another question, which perhaps the TRC was the problem, and that is the question of the beneficiaries of apartheid. You know, at the end of our work, we said that the beneficiaries of apartheid who had successively voted the National Party into government with huge majorities, they didn't come to the party. And in fact, we recommended that there should be a once-off wealth tax in South Africa. And of course, the government didn't take that issue up. But then the question is, who reconciles? Is it the victims who must reconcile? What about the other side? At what point do they commit to a social contract which is about building a new South Africa based on the qualities of equality, dignity and freedom? And that's where I think this exchange has been relatively unfair. And so you can't speak about reconciling victims and perpetrators when the victims have had to give everything up, and those who benefited and those who were directly responsible for the crimes of apartheid have never had to give anything up or pay for anything. I mean, let's be honest, it was only last year, under great pressure, that former President de Klerk actually began to acknowledge the fact that apartheid was declared a crime against humanity. Before that, he was in denial. And I think that's the problem in South Africa, that we haven't really tackled the narrative of denial in our country, that apartheid was an evil system, and those who were responsible for our oppression have never been held accountable. And that perhaps is where the problem lies in South Africa. There's no sense of being responsible for a South Africa that has to be more equal. So when we talk about the question of the fees issue for higher education, that privilege continues. The beneficiaries of apartheid don't have the same challenges that ordinary black South Africans have. The figures for poverty and inequality in our country are extremely high. They're also racialized. And South Africa remains one of the countries with the highest Gini inequality in the world. Why is that? Why is it still possible 27 years down the line?
Can we then talk about a guarantee of non-recurrence in that context?
Well, I would argue that, you know, everything that President Mandela sought to build in that first period when he was in office, and of course the first 10 years of South Africa's history saw a real change in the country with institutions of the state being rebuilt. But overnight, under the Zuma administration, we had these institutions compromised. And today, as we speak, South Africa sits on a precipice because the former president refuses to acknowledge the order of the Constitutional Court that he should appear before the Zondo Commission. And he's encouraging lots of other corrupt leaders to actually do the same. And I would argue then that when we talk the guarantee of non-recurrence, what we are actually inviting are challenges to the Constitution and the constitutional democracy that we fought so hard to rebuild. And that in itself, I think, places us in a very dangerous situation. When you look at the figures around poverty and inequality, many people might say, I can't eat that Constitution. Tell me how it's improved our lives. When you look at the fact that even on the vaccine front, there has been corruption. The fact that countries like Angola and Rwanda and Ghana have been able to vaccinate their populations more quickly. That speaks, I think, to a real problem of both implementation and, of course, corruption in our country. And that's why when we talk guarantee of non-recurrence, I think we have to be extremely careful, because overnight we are seeing our institutions eroded.
Justice remains elusive for the victims of apartheid. That is South African human rights lawyer Yasmin Sooka with us tonight. Yasmin, I appreciate your time. Thank you very much for joining us.